Okay, part 2. I should have made you smash the subscribe button for part 2, and maybe I'll make this like a TikTok video where you don't get any information until, like, I don't know, video 3, and then by that point you're so irritated you stop and go look at a cooking video. I don't know. No, I'm not going to do that. Okay, so the next thing I'm going to talk about is common law marriage. Common law marriage, and we're on 210 to 211. It's just a little bit about common law marriage. Because it's fallen out of favor, and it will continue to fall out of favor. Common law marriage. Is currently only available in 8 states. And even in those 8 states, there's case law on what constitutes a common law marriage. Common law marriage typically requires holding yourself out to be married without the solemnization of it, without the certificate. So typically courts look at a checklist of things. Cohabitation. Names make a difference. What you call each other. Do you call each other husband and wife to the outside world? Does the woman go by the man's last name? That sounds a bit antiquated, but so is common law marriage, so it's fine. Living together, do they have kids? Do they hold themselves out as being married? And then each state will have an individual period of time, and it's typically statutory. Your book has one of 3 years, sometimes it's 7 years, but that has to happen continuously for a period of time before someone can say, or a court could view a common law marriage. And it's a holdover. It's a holdover from a period of time when you couldn't get married very easily, when judges were hard to come by, and we wanted to protect people who really were living in a marriage-type relationship who did not have any other options. We have other options now, so it's falling out of favor. So your book shows you on 217, 8 states and the District of Columbia that still have it. Colorado, Iowa, Kansas, Montana, Rhode Island, South Carolina, Texas, and Utah. There are other states that have abolished it by statute. And another area where other kinds of law are going to impact this is civil procedure. So when you get into practice, you might have someone who comes from one of those states seeking your help, and they say, I come from Colorado, we were in a common law marriage there, comes here. Full faith and credit is what you would look at to determine whether or not they're married in your state, in Kentucky, in Indiana, or wherever you are. So typically in family law situations, receiving states will give full faith and credit to other states' orders. So if you were legally married with a service and paperwork and all that in another state, your marriage is valid in a receiving state, unless it's contrary to public policy. And one of the things that may be contrary to public policy is common law marriage. So someone could come from a state that has common law marriage, and if it's not contrary to your state's public policy, it's a valid marriage. So some states can recognize the common law marriages of other states, but if it's against public policy, or if you have a statute that says such, you won't. And so that's something that you're going to have to take a look at the receiving state and another state to determine how far your common law marriage, if you can have one, will go. And again, they are also falling out of favor. And remember that there are certain characteristics that you have to have. Kentucky's not one of those states that has common law marriage, neither is Indiana, but I know at least someone in this class is intending to practice in Colorado, so that's one of them. And that's really all you need to know about common law marriage. The other 2 things we're talking about in this little section that are not marriage, besides common law marriage, are a putative marriage and presumptions of marriage validity. Okay. The The word putative means generally considered to be. So the presumed marriage, or the one that most people think is real. We will use the word putative to describe marriages and fathers in the context of family law, because marriages and fathers are two things that may or may not be accurate based on the facts, based on what happens in a particular given set of circumstances. And they're also things that change people's financial fortunes drastically. Fatherhood and marriage are absolutely at the top of that list. So, things that people fight about in court. Let's take a look at Spearman versus Spearman on page 220. This is another case where types of law are going to intersect greatly, and in this one, it's wills, trusts, and estate laws. So, Mr. Spearman dies, and there are two Mrs. Spearmans. There's Mrs. Spearman 1, and there's Mrs. Spearman 2. And the problem with this case is that when Mr. Spearman died, he had a life insurance policy that did not designate a beneficiary. This is the problem. If it had a beneficiary on it, the money would have gone to the beneficiary. When we talk, if you've taken wills, trusts, and estates, or if you're going to learn that there are certain things that lie outside of a will or lie outside of an estate, and a life insurance policy is one of those. If I have a life insurance policy and I have the ASPCA as a beneficiary, that's where the money goes, regardless of who are the beneficiaries in my will. That was the big problem, is that it didn't have one. There was a contingency clause in the life insurance policy that said if there was no designated beneficiary, it went to the person's widow. Now this was 1973. So the word widow was probably accurately chosen in 1973. As old as I am, that's before I was even born. So long time ago. Well before all of you were born, I'm sure. So who's the widow? Is it wife 1, who he had kids with? Or is it wife 2, whom he did not? If we look at who the putative widow is, we look at who the putative wife is, isn't it always the second one? No one assumes that the first one that you're not with anymore is going to be the legal spouse. Doesn't make sense, right? So the putative spouse is who we assume the legal spouse is, and that's either the second or the third. It's the last one. However many times you've been married, it's the last one. That's the one that we are going to assume is legal. And if you look at this case, it was not. My friends, this is My Big Fat Greek Wedding 2, the second one. I don't even remember it because it was not as good as the first one. The first one was really good. But My Greek Fat Wedding 2, if you've seen it, is about the young woman's parents who've been, the guy with the Windex and his wife, yeah, the head and the neck, that couple. They've been married forever. Only they didn't realize that their marriage certificate was never turned in, so they realized like 40 years down the road that their marriage was never actually real, and so they'd go and have this big thing, and I don't even remember that. It doesn't matter. That's this case, because wife number 2, who's been thinking that she was actually wife, was not, because he never divorced wife number 1. And wife number 1, he dies, right? She's got kids with him, and wife number 1's like, well, I'm the widow because we were still legally married. And wife number 2 was like, no, you're not. We were married. Well, they both were married. There were 2 ceremonies. So again, another piece of law comes in. This was illegal because it was bigamy. So now we have criminal law coming into this situation. It's not. We can't charge anybody because the guy's dead, and neither of the wives are married twice. It was only the guy that was married twice. So the issue is, who is the spouse? And the case talks about, well, number 1 says they were married. Here's her certificate. Number 2, wife number 2, does not have a divorce certificate. Can't prove that they were actually divorced. So, wife 1 is the legal spouse. The case also talks about wills, trusts, and estate law in terms of the putative spouse. So if someone, for purposes of wills, trusts, and estate law, thinks that they are actually married, believes that they actually were, has a good faith basis to believe that they were, then they can claim part of the estate under a marital property law, or under, sometimes there are, in wills, trusts, and estates, there's the concept of the pretermitted spouse, like, because marriage is a civil contract to financially entwine your finances and take care of each other. Under wills, trust, and estate law, you cannot disinherit your spouse. You can try, but if you don't have a prenup to that effect, you're out of luck. So if you're married and you no longer want your spouse to get your stuff, you have to get divorced. Don't die. Because if you die, then under wills, trust, and estate law, your spouse can take the omitted spouse section, okay? So let's say two people get married. I think this is fascinating. I'll get excited because that's just who I am as a person, and it's not going anywhere. Might make the videos a little bit longer, so I'll try to reel it in when I can, but I get excited. Okay, so you have a husband and wife, don't really like each other anymore. Husband decides to change his will and take his wife completely out of it and say that all of his property, and let's say that they are in a community property state, which you'll learn is basically 50-50. There's some other ways to distribute property when people get divorced, but community property, let's just say 50-50. So he decides to change his will to take 50%, to take all of his property, and let's say he had a lot of separate property from before the marriage, whatnot, and gives it to his girlfriend that wife doesn't know about, okay? Omits wife completely from the will. Under most laws, the wife, or even better, let's say he gives her $500, like some nominal fee. The wife can take what she would have gotten if he had died without a will, which is usually going to be 50%, sometimes even more. So because of the contract to provide for someone, we're not going to let you take that away if you die. If you want to stop being financially responsible for someone, you need to get divorced. You can't omit them from your will. And so that's essentially what wife number two was saying. Wife number two was saying, well, I thought we were married, so I should be able to get my claim of the marital property, which includes this distribution under the life insurance policy, because I was an omitted spouse. And the court in this case said no, because the court said you weren't a good faith spouse. Evidently, Mr. Spearman went back and lived with wife number one once a year, like took family vacations by himself and lived with the wife, with the first wife, the legal wife. Wife number two knew. Wife number two, yeah, it was just, I wrote ha in the side of the book, because it's like, she probably, the court said she probably knew it wasn't a valid marriage, because he kept going back to wife number one for vacations, lived in the same house with her, and probably knew that he had not gotten divorced. So she can't rest on her laurels and say, oh, I thought you got divorced, you know what? No, because of the facts of this particular case. But if she had been able to prove that she was in a good faith, yet not legal marriage, she could have been able to claim some of her rights under wills, trusts, and estate law to get some of that inheritance. So that's what Spearman is about. Okay, so that's also putative spouses. Now we're going to talk a little bit about cohabitation, so living together without getting married. And that is Cates versus Swain, 215 Southeast 3rd, 492. On page 236 of your text. Okay, so this is a situation, 2013, so two women in a relationship before Obergefell, and this is a situation where they were cohabiting. They were cohabiting for a long time. They very likely could not have gotten married in most states because this predated Obergefell. And this is a very similar situation to the cohabitation case we had with the judge and the doctor just a little bit ago. In this case, we've got the opposite result. the court looked at this cohabitation case where these two people did live together, and they had, one of them says we had a marital relationship, and the other one says no, we don't. Cates versus Swain is really about the facts of what happened, and not so much the relationship, but the money. So let's take a look. So Swain and Cates met. They one of them was married at the time and ended up getting divorced eventually, and they started living together. And they started living together in a couple of different states, three different states. And every time they moved to a different state. One of them would take money, give it to the other one to put a down payment on the house. And then it happened again. And so when they split up, and they were never married, when they split up, that person, Swain, that gave all the money from the checking account, from the sale of previous residence, said, I want some of it back. And the other one was like, well, we were married, so you shouldn't get equitable distribution. Who's right? Well, in this case, they both were, because this is not an equitable distribution case. They're not, Swain was not asking the court to treat this like a marriage. Swain was said, look at what we did. And it doesn't really come out and say this, but they were flipping houses. This wasn't the doctor and the lawyer who spent 20 years together and one built a practice and one went on the bench and we're not gonna unentangle their relationship. This was not about the relationship. This would have been the exact same outcome had they not been in a relationship together. And I'm gonna tell you why. So they move, Swain is the person giving Cates equity, she takes the money, buys a house. They do live in the house together, but they flip it within 2 years. Then they did it again. And specifically in the notes that Swain was giving to Cates, this is for a down payment, this is for carpet. She was very smart in saying, this is what this money is for. It's going towards our joint venture. And there's testimony that there were other joint financial ventures that they had gone into together as property investments. This is where this case is different from the doctor and the judge, because they didn't have that pattern. And they didn't have that pattern of documentation. This is for, I'm giving you money for your practice, for the carpet in your practice. They didn't do that. That was much more a marriage and was treated as less than a marriage. This is less like a marriage, and both partners are getting more of their individual financial contribution when it ends. So the reason that these cases are kind of in here together is they show you different aspects, and they might seem like they contradict each other, but they don't when you think about the individual facts of these cases. So if you have questions about these, put them in the discussion thread. The things to take out of these cases are, if you are not married, the court is very unlikely to treat you like you are for any purposes, but specifically property purchases. And if you want to protect yourself financially, do it on paper. And if that means getting married, it may mean getting married. If it doesn't, then at least have the documentation that Swain had. Not only that, but the 2-year issue was a bit of a bigger issue, because if you live in a house if you flip a house, if you sell a house, it makes a difference whether you've lived in it 2 years or 20 years. If you lived in it 20 years, that was your family home. If you lived in it 2 or less, that was long enough to live in it, fix it up, and sell it. So that was the time factor really did matter in determining whether or not the decisions in Cates versus Swain were done as a joint financial venture, or were they done, did we add the sunroom because we wanted a sunroom, or did we add the sunroom because we wanted to increase the value of our property? That's the difference between these two cases. And again, we're not treating this relationship as a marriage, because it's not. And that is consistent across the country. And so the court had said, essentially, notwithstanding their relationship, this would have happened anyway. We're not giving equitable distribution of property. We are treating this as a joint venture and partitioning it as such. Okay, I'm gonna stop again so we can splice, like for part 2, and we're gonna pick up with premarital agreements in just a second.